Morning. In CPC, we are going to see from Order 1. As far as the Civil Procedure Code is concerned, it will, Order 4, Rule 1 will state that the proceedings is commenced by filing of a suit. Order 1, Rule 1 will state who may be joined as plaintiff. Who is the plaintiff person? For a student or any person, even if he is a lawyer, the person who wants to canvass his right against any other person who seems to be violating or is really violating his right or is causing nuisance or is omitting to do an act which gives a right to the right or cause to the plaintiff person who intends to file a proceedings in a civil case is called plaintiff. The term plaintiff will be appropriate is because suit is initiated by filing plaint. Who initiate plaint? Plaintiff initiate plaintiff. Therefore, for the plaintiff to initiate a proceedings, he should have a right. Then he should know what is his right. Then he should know how he should pursue his right. Then he should know in what manner he has to pursue his right. Then he should know how and why he is pursuing his right. Without answering all these questions, if a plaintiff comes to court, he will definitely fail. Therefore, a person who intends to file a plaint is the plaintiff. Therefore, all the persons who wanted a particular cause, either in common or as individual, can be joined as plaintiff or can be shown as plaintiff. Then Order 1, Rule 2 will state the power of the court to order separate trial. Why this? That is why I said the plaintiff should know how he pursues his litigation. Therefore, if the plaintiff has different cause or different relief against various persons who were or are added as parties, the court, if it deems fit, that all the cause, relief, or an issue cannot be decided in the same suit, the court can order separate trial. One may ask, sir, I have filed one suit. How the court can order separate trial? Yes, this is because the code itself provides that the court can go for a separate trial in respect of various relief. Therefore, the court can split the trial. It is not that it is going to go for separate suits. It is only going to order separate trial in respect of various rights or relief. Therefore, one need not confuse themselves by asking a question. I am filed one suit. Why the court should order separate trial? Hope this answers your query in respect of Order 1 Rule. Then Order 2, Order 1 Rule 3, who may be joined as defendants. Normally, the plaintiff is the dominus litis. Who is dominus? What is dominus litis? He is the person who is coming forward with a litigation. Therefore, he dominates the litigation. as far as the process of litigation is concerned. Therefore, he is called dominus litis. Therefore, when the plaintiff choose a particular person to be a defendant, if there is a cause, if there is a possibility of granting relief, if there is a prima facie case to sustain the plaint, the court cannot refuse saying that it has a doubt whether the plaintiff will be in a position to prove his case against the defendant. Therefore, the plaintiff chooses against whom he wishes to sue. Therefore, the person who is sued is called a defendant. Any person against whom a relief is sought is called as defendant. Then it would state where separate suits had been filed. If there is a common question of law or fact, the court can also determine the issues in common by way of a common trial, simultaneous trial, or in whatever form the court deems it fit to decide the particular case on hand. Therefore, we have seen who is the plaintiff, who is the defendant. Normally, what will happen? The person who is infringing or who is causing the trouble in not permitting the plaintiff to enjoy his right is joined as defendant. Now, we will not go into the issue of whether a person can get himself impleaded. What if plaintiff is going to object? That we will see when the situation comes. Now, what we'll do is we'll go to Order 1, Rule 4. The court may give judgment for or against one or more of the joint parties. Therefore, what is intended in this provision is that after the trial is over, the court can decide whether it has to pass judgment against single plaintiff if there is more than one plaintiff, single defendant if there is more defendant, or if there is more plaintiff or one plaintiff, less than one or more defendant, the court can choose against whom such judgment can be passed. Then Order 1, Rule 5 would state that defendant need not be interested in all the release claim. Why this is so? Because there may be in some cases where the defendant may be proper party, but they may not be necessary parties. This will arise only if there are several defendants. Order 1, Rule 5 can be applied only if there is several defendants. Where there is one defendant, the question of saying that he may not be interested in all the release claim will not arise is because the plaintiff has claimed relief only as against that particular defendant. Therefore, the question of saying that the plaintiff is interested in the relief and the defendant is not interested in such relief. But the court can always say the plaintiff cannot claim such a relief as against this defendant. That is for the court to give reasons when it passes a judgment. Joinder of parties liable on the same contract. What does it mean? See, the plaintiff has filed a suit. There is a contract. The contract has several parties, in which case it would be prudent for the plaintiff to join all the parties under the same contract. Then the plaintiff can seek his relief, whether it is specific relief or compensatory relief that is sought. Because under the contract, there can be only two such relief, which would be a specific relief or a compensatory relief that is sought. Then we'll go to Order 1, Rule 7. Order 1, Rule 7 would state, when plaintiff in doubt from whom redress is sought, where the plaintiff is in doubt as to the person from whom he is entitled to obtain relief, he may join two or more defendants in order that the question as to which defendant is liable and to what extent may be determined as between all the parties. Therefore, if the plaintiff has a doubt as to the relief that he has to claim, but he knows for certain the person against whom he has to claim relief, he can join all of them and the court will determine against whom such a relief can be granted. Order 1, Rule 8. One person may sue or defend on behalf of all in the same interest. This is called representative suit. Order 1, Rule 8 is called representative suit. Where you file a suit as a representative suit, you will have to file an application under Order 1, Rule 8 for permission of the court to proceed with the plaint as a representative cause. In such case, the court will order paper publication to be effected in the locality which is sought to be represented by the plaintiff or the plaintiffs, and after the paper publication is effected, the suit will be directed to be numbered after permitting Order 1, Rule 8. This is so is because when the plaintiff dies, plaintiff or plaintiffs die, the cause will not die since it is a representative cause, and any one of the person who is also interested in such cause and for whom the suit had been filed as a representative cause can continue by filing an application before the court that he may be permitted to continue the suit. It would only be a formality if such a person comes before the court. Therefore, Order 1, Rule A2 would state that a permission to come before the court with public advertisement should be made. Therefore, 3 will state any person on whose or for whose suit is instituted or defendant may apply to the court to be made a party to such suit. That is what I told you just prior. No part of the claim in such suit shall be abandoned, and no suit shall be withdrawn under sub-rule 3 of 1 of Order 23, and no agreement, compromise, or satisfaction shall be recorded in such suit under Order 3 of that order unless the court has given at the plaintiff expense notice to all persons so interested in the manner specified in the sub-rule. What does it mean? Court would state that you cannot withdraw the suit once an application under Order 1, Rule 8.3 is allowed, and or the suit can be compromised. Therefore, on both the occasions, the court will only order a notice to be given to all the interested parties. How can a notice be served on all the parties? Again, it would be by way of a paper publication in the local newspaper or something by which all persons concerned will be informed that the suit is going to be withdrawn, and any person who is interested to continue the suit can come forward and apply to the court to continue the suit or to permit the suit to be withdrawn by the plaintiff. That is what is the notice that to be given. Where any person suing or defending in any such suit does not proceed with due diligence in the suit or defense, the court may substitute in his place any other person having same interest in the suit. This is Order 1, Rule 8.5. Therefore, if A comes forward and files a representative suit, A does not continue the suit in a diligent manner, the court finds that B is having same interest in the issue relating to the suit. The court can direct B be impleaded as party in the suit. Then Order 1, Rule 8.6, a decree passed in the suit under this rule shall be binding on all persons on whose behalf or for whose benefit the suit is instituted or defended as the case. It is only to show that the decree passed is binding, whether you are a plaintiff or the defendant, on all the persons who are part of the society, who is sued or who sues or who is sued as in a representative capacity. Then Order 1 fully power of the court to permit a person or body to present opinion or take part in the proceeding. What will happen when we say that parties to the proceedings are plaintiff and the defendant? How come other parties can be permitted to take part in the proceedings? In these type of proceedings, the code itself provides that under Order 1 to 8, the court can join a person, permit a person, body of persons to present its opinion or take part in the proceedings. Therefore, in all these cases where, say, a trust is involved, a temple is involved, or it is for a purpose of a village, town, market, in all these cases, the court can always say, yes, we'll go ahead and ask these people for their opinion or make them parties to the proceeding or may permit them to take part in the proceedings and pass a judgment. This will also be because those persons who are permitted to take part in the proceedings will also be bound by the judgment given by the court. Then misjoinder and non-joinder of parties. What does that mean? First, plaintiff is supposed to join all the persons who are interested in the relief that he has claimed. There he omits to join somebody, it is called misjoinder, non-joinder. What is misjoinder? A plaintiff brings in a wrong defendant. That is called misjoinder. Therefore, the basic differences between non-joinder and misjoinder is non-joinder is not joining a person. Misjoinder is not joining the right person. That is the part of the term that is used here in Order 1, Rule 9. Therefore, it would state, no suit shall be defeated by reason of misjoinder of non-joinder of parties, and the court may in every suit deal with the matter at controversy so far as regards the right and interest of the parties actually before it, provided nothing in the rule shall apply to non-joinder of a necessary party. What does it mean here? In the first portion, the court will say no suit shall be defeated by reason of non-joinder or misjoinder of parties. And the court may go ahead, determine the right of the parties before it. Proviso will add, it does not take away the meaning of what is given in the main section. It only adds saying that as far as non-joinder of parties, the above provision will not, the above rule will not apply. Why? Previously, it itself states misjoinder and non-joinder will not defeat the right, will not defeat the suit. Then it would state for non-joinder, it will not. Why is because non-joinder means a party does not know about the proceedings itself. Therefore, one cannot expect that any judgment passed against him without he being a party should bind him. Therefore, person who is not a party to the proceedings cannot be bound by the judgment that is given by a court. This is the purpose. Therefore, The proviso hastens to add, saying that for non-joinder of parties, this rule will not apply. However, the court can determine the rights of the parties who are before court. Therefore, only the party to the list is bound by the judgment. This is what the Order 1, Rule 9 states. Then, suit in the name of wrong plaintiff. Where a suit has been instituted in the name of wrong plaintiff, or where it is doubtful whether it has been instituted in the name of right plaintiff, the court may at any time, a stage of the suit, if satisfied, the suit has been instituted through a bona fide mistake, and it is necessary for the determination of real matter dispute to do so, order any other person to be substituted or order as plaintiff on the terms as the court thinks. Here, this provision is made only for the court to determine whether wrong plaintiff has come before the court, not for the party. However, the party can also come forward and say, I have filed the suit. Anyhow, the other person should have filed the suit. I do not know that my right is superseded by the other person's right. He can come forward and say, and can seek to bring him as plaintiff and substitute him as plaintiff in his name, in his place, or the person who has a better right than the plaintiff can come forward by himself filing an application to implead and transpose him as plaintiff. And in such cases, on an application or by the court itself, that is what Order 1, Rule 10(1) states, the court itself also can implead the right plaintiff who has to be joined on such terms. Then court may strike out or add parties. What does that mean? If a wrong plaintiff or defendant is added, or one of the plaintiff or one of the defendant is not a necessary party to the suit, and to be burden for the person as well as the court who have him in the litigation, court may add or strike such parties from the litigation. That is the intention of Order 10, Order 1, Rule 10(2). Then 3, no person shall be added as a plaintiff suing without an ex friend or as an ex friend of the plaintiff under any disability without his consent. Clearly, yes. See, a plaintiff is disabled. What does that mean? He is a minor. He is of unsound, or he is sick to that extent that he cannot determine for himself. All these things will be dealt with under Order 32, Code of Civil Procedure. Here, what is stated is, if such a friend is added as a party, then the court should take his consent to be next friend for the plaintiff or the defendant. It only talks about the plaintiff, not about the defendant. Therefore, will not go for the plaintiff. Therefore, if a suit is filed on behalf of as next friend of these persons, a consent should also be filed by the next friend saying that he is consenting to be the next friend of such a person in respect of the present litigation. And he has no objection and he has no interest in the cause. Then Order 1, Rule 10(4), where defendant added plaint to be amended. What does that mean? Plaint is filed against defendant. Now we have seen that the court may strike or add defendant. Where a defendant is added, he has to be brought on record. Therefore, cause title, short cause title, long cause title, address, and effectively the pleadings and cause, leave, everything has to be amended. Therefore, Order 6, Rule 18 application, seeking permission of the court to carry out the amendment in the necessary form has to be filed by the plaintiff, and such application filed has to be considered and allowed by the court, and giving reasonable time for the plaintiff to carry out such an amendment in Rule I. Subject to the provisions of Indian Limited, proceedings as against any person added as defendant shall be deemed to have begun only on the service of this. I have been added at the after 4 years or 5 years from the date the plaintiff is presented. And relief cannot be granted by the court, saying that the relief will, this is only to curtail the doctrine of relation back to the date on which a summons is issued to the defendant. Now, what is doctrine of relation back? Doctrine of relation back is that if a suit is filed, the relief that is granted by the court relates back to the date on which the plaintiff is presented. Therefore, to curtail the doctrine of relation back to the added party, the court states that in all these cases, the person is deemed to have come into the picture only on the date the summons is issued. Therefore, the doctrine of relation act will only run from the date they were added as parties. Then, conduct of suit in respect of such persons. What does it mean? 11. I may take a plea. I have not been added as party in the original instance. Why I should be added now? Therefore, the suit is wrong. It should be rejected and let him file a fresh suit. No. Board itself states, therefore, person is added. You should not take such a plea, and the proceedings are deemed to be proper from even after adding such a appearance of one of several plaintiff or defendant for others. What does that mean here? See, it may not be possible for all the plaintiffs to appear and proceed with the case, as well as for all the defendants to appear and proceed with the case. Therefore, in such cases, the code itself under Order 1 Rule 2 permit that the plaintiff or the defendant, whoever wants to sue the litigation for the other, can be authorized by the other person who may appear, plead, or for such acts during the proceedings. Objection as to non-joinder or misjoinder of parties. Order 1. All objections on the ground of non-joinder or misjoinder shall be taken at the earliest possible opportunity, and in all cases where issues are settled at or before such settlement, unless the ground of objection has subsequently arisen, any such objection not taken shall be deemed to be waived. One would wonder how this can happen. I am not a party at all. That is why there is a non-joinder of parties. Then where is the question of saying that I would have waived if I don't raise it before the settlement of issues? That this will arise only if the party before the court, this is only for the party before the court to say that there is a misjoinder of non-joinder of parties. Once he does not raise that plea before the court, before the issues are settled, the party to a suit cannot raise the plea. This is what the is the meaning under Order 1, Rule 13. It is not for the party who is not impleaded or who is misdirected against, or A is impleaded instead of B. That is not the case. Where what is stated is the party who is there before the court should take the plea of joinder of before the issues is settled. Once you don't take such a plea, you are prevented from taking such plea. After that, in the suit, continuation of suit as appeal, revision, wherever. Therefore, such a plea is deemed to have been waived if you don't raise it before the settlement of issues. However, there is one more sentence that is there, unless the ground of objection has subsequently arisen. One should also mind this word that is used. Why does this particular thing has been provided? There has been an amendment after the settlement of issues, or there is an application to include a party that is allowed. All such cases, person, plaintiff or defendant can always come before the court. Only plaintiff will not say there is a misjoinder or non-joinder of parties. It's always the defendant who is going to say there is a non-joinder of necessary misjoinder of necessary parties. Such a case, if it has subsequently arisen, he is not prevented. He is prevented only in respect of the original cause after the settlement of issue. Now, Order 2, Rule 2. Frame of suit is a suit. Suit is initiated by filing plaint. That is what Order 4, Rule 1 will state. Every suit shall, as far as practical, be framed so as to afford ground for final disposition upon the subject in dispute and to prevent further litigation concerning them. This is Order 2, Rule 1. What does that mean? It says that you should frame the suit in such a manner that you cover all the aspects in respect of litigation in one suit and give a ground for final decision in respect of a dispute. Thereby, multiplicity of proceedings is, that is Order 2. Then Order 2 suit plaint. Plaint. That is what I told in the beginning. Plaintiff to come forward by knowing his right, he should state all his right. Particulars should be given. Particulars of evidence that he possesses in respect of such should be given. Material particulars leading to his right, infringement thereof, or omission or commission which gives right to file a suit should be properly pleaded, and the suit should be for all or whole of the claim that arises under the particular act or transaction that is pleaded by the plaintiff. Then what does it say? Order 2, Rule 2 states where if the plaintiff omits to sue in respect of intentionally relinquishes any portion of his claim, he shall not afterwards sue in respect of the portion so omitted. Or what does that mean? I have a sought for a relief of declaration, where I should also seek a relief of possession, because possession is not with the plaintiff, it is with the defendant. Where the plaintiff omits to claim the relief of possession, what will happen? He cannot, because he has omitted consciously, intentionally. Therefore, he cannot file a separate suit for possession in respect of the same. That is what Order 2 Rule 2. Omission to sue for one of several relief. Person entitled to 2 and 3 are almost similar is because portion of the claim are under several relief. What is portion of the claim and several relief? Portion of the relief we can even say I'm entitled to 2 lakhs from the defendant. I claim only 1 lakh. Then I'm not entitled to claim the other portion in a separate suit. Several relief. That is what I told you. If I claim declaration, if possession is not sought for, then I am not entitled. Where I file a suit for specific performance, where I have several portions of the property on the same agreement. I file a suit only in respect of some portion of the property in respect of which the agreement is entered into between the parties. Then the party is not entitled to file a separate suit. Explanation. With the except the leave of the court. What is except the leave of the court? Where there may be certain relief or a portion of relief which can be claimed only later. Therefore, what we will do is, in such a case, we will file an application before the court under Order to Rule 3, seeking relief, leave of the court to retain our right to claim that portion of the relief or the other reliefs that are not claimed in the suit. And if leave is granted, then we are not bound by Order 1, Order 2, Rule 1 or Order 2, Rule 2. Where no such leave is granted, then there will be a bar for the purpose of claiming the relief. Then Order 3, Rule 3 will state joinder of cause of. Joinder of cause of. We normally state that we, as against the defendant, has a right which is in the actions of infringement and the what are all the events that amounts to an infringement amounts to cause of, where you have omitted to join several cause of actions on for in respect of the same cause, then you cannot seek to bring another suit. Therefore, Order 2 Rule 3 would state you have to unite all those causes and institute a suit. Only certain claims to be joined for recovery of immovable property. What does that mean? That would mean that in respect of an immovable property, where it would amount to a different cause of action or claiming different relief in respect of a different action itself. Therefore, Order 1 Rule, Order 2 Rule 4 would state only such of those claims which should fall part of the same cause of action can be joined. Then Order 2 Rule 5, claim by or against an executor, administrator or heir. No claim by against an executor, administrator as such shall be joined with claims by or against him personally unless the last mentioned claims are alleged to arise with reference to the estate in respect of which the plaintiff or defendant sues or is sued as executor, administrator, or heir, or such as is entitled to or liable or jointly with the deceased person whom he represents. What does that mean? an administrator, executor, or representative, or a different or persons who is representing the estate for the other person. Therefore, this code would state kindly avoid joining because individually against the person as an individual and also as executor, administrator, or representative, unless what it is jointly embedded in such process of the event. Power of the court to order separate trials. Where there is joinder of several causes, the court can order separate trial. This we have already discussed in order one. Order one. Objection as to misjoinder. All objections on the ground of misjoinder of cause of action shall be taken at the earliest opportunity, and in all cases where issues are settled at or before settlement, unless the ground of objection is equal to release. Any such objection not so taken shall be deemed to same thing as previously order one. Similar provision has been instituted, has also been included here, like misjoinder and non-joinder of parties. Misjoinder of cause of action is also included here. What does that mean? A misjoinder of cause of action, if not pleaded, amounts to waiver, unless such misjoinder has arisen later prior to the settlement of issue. Therefore, if the defendant does not take the objection as to misjoinder of cause of action, then he is not, before the framing of issues, then he is deemed to have waived misjoinder of issues, claim as to misjoinder of issues at any point of time during trial or in any proceedings subsequent to the settlement of then order three. Recognized agents and pleaders. Yes, that means, see, there may be litigations which are filed through power of attorney. Therefore, this provision, Order 3, enables the proceedings to be filed or defended through the recognized agents. What is required in such cases? The recognized agent should come before the court, seek a permission under Order 3, Rule 1, stating that he is suing or he is, has to be sued by such representative to the agent, and court will look into the uh, power of attorney, the act which the agent has done for the principal and whether it is related. And then the court will order such power of attorney agent to participate. Such permission does not necessarily mean that the agent can give evidence on behalf of the principal except for acts which are of his merits. Order. Order 3, Rule 2. Recognized agent. Same thing, power of attorney, carrying on business. Order 2, Order 3, Rule 2, and Order Rule 16, 1 and 2 of Civil Rules of Practice will be almost similar. Because Civil Rules of Practice is framed under 121. Therefore, what it will state is that for such appearance of the parties, uh, they should be connected with the business or for making such an application and other things. That is what it says. Similar provision is also provided under the uh, civil rules of practice. Service of process and recognition. What does that mean? If agent, a person is being represented by agent or is shown to be represented by an then a notice on the agent is sufficient for the purpose of service in respect of the suit or appointment of a pleader. And only under this provision we take wakalat. Only under Order 3, Rule 4, advocate or pleader takes wakalat from the party. Order 3, Rule 4 is the provision which enables party to engage a pleader to plead on his behalf. This is more or less like a power of attorney. Therefore, he can always do all such acts that is provided for under Order 3, Rule 4. Therefore, in such cases, the wakalat form as prescribed is framed to comply with Order 3, Rule 4 of the Civil Procedure Code. Service on process on pleader. Yes, it is always natural that once a party is represented by a pleader, the notice of process in respect of such proceedings can always be served on the pleader, and such service of process on the pleader is deemed to be proper, and it completes the service. Agent to accept the service. If any process is attempted to be served on the agent is bound to accept the service unless otherwise he is not authorized to accept such. And appointment to be in writing and to be filed in court is what Order 6 rule is. Always, what will happen if an agent is appointed? It should be in writing and it should be filed in court. The court may at any stage of the suit order any party not having a residing within the jurisdiction who has been duly appointed to appoint within a specified time an agent residing within the jurisdiction of the court to accept the service on the of the process on this. It's not only for accepting the process. The court can always say the party who is not residing within the jurisdiction of the court to appoint an agent for the purpose of conduct. Then Order 4 state initiation of suit. Initiation of suit is commenced by filing of a plaint. Every suit shall be initiated by presenting a plaint in duplicate to the court or such officer as it appoints in this behalf. Every plaint shall comply with the rules contained in Order 6 and Order 7 so far as they are applicable. Plaint shall not be deemed to be duly instituted unless it complies with the requirements specified in Rule 1. Does that mean it is specific? The court says that the plaint should comply with Order 6 and 7 of the Code of Civil Procedure. Therefore, the contents of the plaint has been dealt with under Order 6 and 7 of the Code. Therefore, contents of the plaint should be as per Order 6, Rule 7. Therefore, and it should also be filed in duplicate. It should be filed in duplicate. The plaint should be filed in duplicate. Therefore, plaint should be filed in duplicate and it should be as per Rule 1 and 2 as above. Rule 1 and 2 as above is presentation before the court or authority also is required. Therefore, all these things is considered as presentation or institution of a suit. Then register of suit. Once the court scrutinizes the suit, the court will have register of plaint register called suit register or plaint register. So in that the court will enter the details of the plaint that is given in the by the plaintiff, like who is the plaintiff, who is the defendant, what is the cause of action, what is the jurisdiction, what is the court fee, what is the relief sought for. All these things will be entered in the suit register. Therefore, If a person wants to inquire what is the suit that is filed against another, it would be sufficient if he inspects the suit register and finds how it is done. From that, he can also find the name of the parties in the suit number, court in which it is proceeding, pending, and what is the relief that is. For that purpose, the suit registration. Order 5, issue and service of summons. We have seen parties to the suit, presentation of the plaint, how a relief has to be claimed, or joinder of cause of action, representative thing, everything is seen now. Issue and service of summons. We have come to a stage why Order 5 itself deals with issue and service of summons when 6 and 7 deals with plaint. Summons is also to be enclosed along with the plaint. Suit summons should and bata is also to be enclosed along with the plaint. Therefore, code has consciously dealt with the issue of service of summons in order 5 before it goes to order 6 and order 6 and 7, where it deals with the contents of the claim. Therefore, please understand summons should accompany the plaint. What is a summons? When a suit has been duly instituted, summons may be issued to the defendant to appear and answer the claim and to file written statement of his defense if in 30 days from the date of service of summons, provided that no summons shall be issued when a defendant has appeared at the presentation of plaint, admitted the plaintiff's claim. Provided for that, where the defendant fails to file the written statement within the set period of 30 days, he shall be allowed to file the same on such other day as may be specified by the court for the reasons to be recorded in writing, but shall not be later than 90 days from the date of service of summons. So, for all these three states, if suit is properly filed and entered in the suit register, a summons is issued for filing, for appearance and filing of written statement within 30 days. Where the defendant appears at the time of presentation of plaintiff himself and admits the claim of the plaintiff, the court can proceed to uh, pass the judgment on the basis of admission and order 12 rule 6. Therefore, no summons need to be issued. That is what the first proviso says. The second proviso would state where the defendant did not file within 30 days, but the court has granted time for the defendant to file a written statement, it should be only up to 90 days from the date of service of the summons. What will happen if the summons is issued? The defendant should appear to advocate or pleader. Copy of the plaint to be annexed to summons. That is what I told you. The summons will accompany the plaint. Therefore, the summons should also be enclosed with a copy of the plaint. Court may order defendant or plaintiff to appear in person. Where the court sees reason to require personal appearance of the defendant, the summons shall order him to appear in person in the court on the day specified. Personal reasons of the plaintiff shall order and pass an order for such appearance. Therefore, the court, if it feels at the time of issuing summons the personal appearance of the defendant and plaintiff, it can issue summons for both of them to appear in person. No party to be ordered to appear in person unless residing within certain limits. What does that mean? The person who is ordered to be appeared before the court and order I rule 3 should be a person who is residing within the jurisdiction. Otherwise, the court shall not, and 4B also state it should be within less than 50 kilometers. And less than 200 kilometers from the courthouse. That is what it says. Therefore, unless a person resides within the jurisdiction of court or he is residing as per under order 5 Rule 4.2, so 4b, the court cannot order personal appearance. Summons to be either to settle issues or for final decision. What does that mean, sir? Your written statement itself is not filed. How can the court can order issue of summons for settlement of issues or for trial? The summons that is spoken to under Order 5, Rule 5 is summons to settle issue or for final disposal. This does mean where the plaintiff alone has appeared or the defendant has also appeared and it is necessary the appearance of the parties is required for the court to settle the issue or to commence trial. A summons is issued under Order 5, Rule 5. Where the suit is to be heard by a small class court, a summons shall be issued for the final disposal. So, the direction to a small class court which hears the civil case under the Code of Civil Procedure Code is required to issue a notice for final disposal. Fixing date for appearance of defendant. What does that mean, sir? Here, the court fix the date for appearance of the defendant, then alone it issues summons. Therefore, that is what Order 5, Rule 7 states. Summons to order defendant to to produce documents relied on by him. That is next. Order 5, Rule 6 states that the court will fix the date on which the defendant shall appear for the purpose of defending the suit. Thereafter, issue summons. Order 7, Rule 7 is directing summons is issued to the defendant to produce the document in his possession where the plaintiff pleads or the defendant has said in the written statement that those documents are in his possession. The court can issue summons for the defendant to produce those documents. On issue of summons for final disposal, defendant to be directed to produce this. What does that mean? Where a summons is issued for final disposal of the suit, defendant shall be directed to produce his witnesses. Means here already the trial has commenced. The plaintiff evidence is over. At that stage, the court issues a summons for final disposal to the defendant to appear along with his witness. That is what is stated in Order 5, Rule 8. Delivery of summons by court. There are several means of delivery by court, by post. The summons is delivered. Where it is by delivery through court, the person called bailiff will go from the court through which a summons is directed to be delivered on the defendant. Then he will file a statement along with an affidavit that the summons was served on the person who is on whom it is directed to be served. Where this person is not present, that person will also state who has identified the person to whom it is served and what is the relation of the person who has received the summons. The court, upon receipt of such bailiff report, either will treat the summons issued to the defendant as complete, service of summons on the defendant as complete, or may order fresh summons to be issued to the defendant, depending. There are certain instances where the bailiff will also go there, affix the summons saying that the defendant is not present, nor any person is present whenever I went there. Therefore, at the presence of somebody who is very important, like VAO, or some of the person who is an adult in the next door who is properly identified in his presence, I have affixed the summons. Therefore, kindly note down the affixture. He will make a request to the court saying that he has affixed the notice on the last known address of the court will state that notice is affixed in the last known address of the defendant. And It may also order publication. Summons given to the plaintiff for service. The court may also give the plaintiff summons to serve on the defendant, in which case the plaintiff will either can personally serve or send it by registered post, in which case he should get due acknowledgement for service on the defendant or who's any of the adult member of his family or through his authorized agent. Mode of service. Service of summons shall be made by delivering or tendering a copy thereof signed by the judge or such officer as he appoints in this behalf and sealed with the seal of the court. Or it should always be signed and sealed with the affixture of seal by the court or of the officer of the court. Service on the defendants, several defendants. In normal manner, same as that of the defendant, it will be sent. Service of to be on defendant in person when practicable or on his agent. It is what we were talking. Where it is possible to serve the defendant, it will be served. Or it will be served on the agent or on any of his adult member of his family. 13 speaks about service on the agent who carries on business. Order 3, Rule 2, and it should state that where a agent carries on business on behalf of the principal, he represents the principal. Therefore, in all these cases, summons can be served on such an agent who carries on business on behalf of the defendant. Service on agent in charge in suits of for immovable property. What does that mean? An agent is in possession on behalf of the principal for the purpose of the immovable property. Therefore, the service of summons can also be served on the agent who is in possession of the immovable property for which a suit is filed. Where service may be on adult member of the defendant family. That is what we have spoken to all about. Person served to sign the acknowledgement. Yes, we have also spoken to about procedure where defendant refuses to accept or cannot be found. When the defendant refuses to accept, it is deemed to be accepted. Where he cannot be found, the court will either order a fixture or the next stage of service of summons will be followed. Endorsement of time and manner of service. That is what I told you. 18 and 90 relates to how the officer who goes for service shall make an endorsement on such summons. Simultaneous issue of summons for service by post in addition to personal service. Personal service is through the court bailiff, officer of the court, and through post also. That is what the court may order, court and post. That is how normally the summons is served. 20 is substituted service. What is substituted service? CNB LKR and through paper publication. CNB LKR Court Notice Board. CNB LKR is last known residence. So an affixture is effected in CNB LKR Court Notice Board and last known residence along with a publication to be effected in a local newspaper where the defendant is shown to be residing or carries on business in the place. Likewise, the service of summons through to foreign countries, everything has been spoken to where you can either send by airmail or you can serve through the uh, what you call the uh, our high commission of the country. Service of soldiers and sailors and airmen will be to the commanding officer of the regiment in which he works. With this, we'll end today's